In New Berlin, Wisconsin, just outside of Milwaukee, a compliance officer for OSHA was driving past an apartment building where Avalos Home Improvements was performing a re-roofing project. Believing that there were potential fall protection violations, the compliance officer stopped and conducted an inspection, which resulted in a citation. The owner of Avalos Home Improvements, Julio Avalos, signed an expedited informal settlement agreement and then, days later, issued a notice of contest. The administrative law judge was therefore forced to evaluate whether or not the expedited informal settlement agreement was binding or whether or not to acknowledge the notice of contest. We're going to discuss how the administrative law judge handled that dilemma in this, the November 19th, 2025 edition of the OSHA 3030. Hello, everyone. I'm Manesh, Rath, a partner at the law firm Keller and Heckman here in Washington, D.C. Welcome to the OSHA 3030. I'm joined today by my friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030. Thank you for joining us.
Thank you, Manesh. Always great to be here.
It's great to have you here. We've got an interesting topic. Ben, I don't think we've ever discussed in maybe 13 years times 12 months, we've never addressed a case that's come before an administrative law judge or an Article 3 court that dealt with the instrument at question here, the expedited informal settlement agreement.
Yeah, that's right. I think it's going to give us a unique look into that process, which I think is sometimes overlooked in many of the cases that we cover.
I'm excited to go into a new topic that we've never covered before. Why don't we get into it by starting with what we're going to talk about today?
Yeah, exactly. So we'll begin with an overview of the facts in this case, which will cover the incident, the inspection, the citation, and the eventual motions that you mentioned, discussing the validity of the EISA agreement. Then we'll get into the arguments raised by both sides, and ultimately the ALJ's decision on the matter, and conclude always, as we do, with the what employers should do section.
Yeah, and in that section, we offer, as we do every month, practical takeaway items that each of you in the OSHA 3030 community can go back to your workplaces and maybe implement one or two things that you've picked up from the program that'll make your compliance program and your defenses just a little bit stronger. So why don't we get going with the facts of the case?
Let's do it. So the background. So we have, like you mentioned, Avalos Home Improvements LLC, which is a small contractor, as we see, located just outside of Milwaukee, Wisconsin. They perform general contracting work. And in this particular instance, they were performing a re-roofing job in an apartment building in a suburb of Milwaukee known as New Berlin. When a compliance officer drove by and noticed some potential fall protection violations. After noticing the violation, the inspector pulled over, conducted an inspection on site, and went through with the process.
And I should stop there and say, Ben, as you know, but many of our members of our OSHA 3030 community would benefit from knowing, there is a doctrine in OSHA law called the plain view doctrine.
Right.
And it renders the construction industry particularly susceptible to this doctrine. And the idea is that anything a compliance officer can see in plain view is fair game for them to follow up with an inspection. This affects all of our clients in every sector, including even enclosed indoors manufacturing. If a compliance officer happens on the basis of a complaint about one thing to walk through a factory floor, for example, but along the way to the site that he is destined to inspect, he or she sees some other potential violation, that secondary development, because it's in plain view to the compliance officer, gives them the opportunity to follow up and investigate that as well. This goes to the overlying or background legal question of probable cause and when an inspector can conduct an inspection, on-site physical inspection, and when they need a warrant, for example, or permission from the employer. And the question of probable cause can be addressed succinctly if they see a potential violation in plain view, and that makes it fair game. That's sort of a shortcut as to whether or not they have probable cause to come in, and that's what happened here. And as I say, construction operations are particularly susceptible to that because they're often outdoors and visible by the roadside, and so it's very easy for a compliance officer driving by to see potential violations. Oftentimes, we see this, Ben, you and I, we do a lot of work in the construction sector, and we see this with trenching, excavations, fall protection. These two jump up the most because they're just readily visible to inspectors driving by. So go ahead.
Right. So let's discuss what took place in the inspection portion of this case. So once the CO arrived, he held a opening conference with Julio Avalos. As we'll discuss in greater detail. It's important that opening conference was conducted in English, and Avalos was identified as the person who is in charge of the work site. And during this process, Avalos never indicated that he did not understand English. And later, the CO would go on to testify that nothing suggested that he had difficulty understanding what was being said. I think one thing that we discussed before this, as we were preparing for the show, is that what was interesting is that during the closing conference section of the process, that was also conducted in English, but there was an interesting occurrence where while this was taking place, a coworker of the CEO called the CEO, and that coworker spoke in Spanish, and the CEO asked that coworker to, over the telephone, conduct essentially another closing conference with Mr. Avalos to confirm that he understood what was taking place.
It's interesting, Ben, because the administrative law judge, the way he describes it in his opinion, is that, as you say, the compliance officer didn't get any sense from the closing conference that Julio Avalos had any difficulty with the English language. The administrative law judge then speculates if the compliance officer had perceived that Mr. Avalos was having any difficulty, he would have contracted with the agency's translator on staff, a bilingual coworker. That is pure speculation, whether sua sponte from the judge or whether the compliance officer testified that way. If the compliance officer had said in testimony, if I had perceived any difficulty on the part of the manager, in this case business owner, with his ability to speak English, I would have called one of my coworkers who could provide translation services. I would have objected to that testimony as pure speculation, and it is an objectionable testimony. And so I don't think that it's appropriate for the judge to recite that as part of the facts in the opinion without citing to some evidence that was supplied at trial beyond merely speculative testimony. Then he goes on to say, by sheer coincidence during that meeting, and that phrase is upsetting as well. By sheer coincidence, a Spanish-speaking colleague happened to call the compliance officer about an unrelated matter. And here's the other phrase that I find troubling in the opinion. As a precautionary measure, the compliance officer calls in that colleague and asks him to hold a second closing conference in Spanish. But if indeed it's as the judge has described it, that this was a pure coincidence and that the compliance officer nevertheless thought that it would be nothing more than a pure precautionary measure to have a second conference in Spanish, that precautionary measure is a tacit admission on the part of the compliance officer that the precaution was worth taking. And that maybe there was some question as to Julio Avalos's ability to handle the closing conference in English. And so those are all, I think, very troubling facts for the agency. And I think that they should have been treated with maybe a greater deal of skepticism at the tribunal stage in order that the testimony by Julio Avalos either be given the benefit of the doubt or be refuted by evidence other than speculative testimony, one or the other.
Right. And I think it's unfortunate that it doesn't seem that Avalos's representatives in this case brought this up.
And he wasn't represented at that stage, was he?
Well, during the discussions in opposition.
Right, during the arguments. Yeah, that's right.
So, after the inspection took place, a citation was issued on June 14th. The citation was issued under the fall protection standard. It alleged a pretty hefty penalty of around $14,000, a little less. And the citation packet that was transmitted over to Avalos was in English. However, the cover note to the citation packet, including a warning in Spanish in bold, oversized font that roughly translated into This document is very important. If you have any, if you do not speak English, find a translator or call the area office phone number. Um, the cover letter indicated that Avalos had three options to respond to the citation. He could settle through an EIS. He could hold,
And the expedited informal settlement agreement.
yes, he could hold an informal settlement conference with OSHA to discuss further, which, as we always discuss, is not told the 15-day working period. Important to know. Or he could contest the citation within 15 working days.
Yeah, and that first option where they offered him the opportunity to enter into an expedited informal settlement agreement, the sweetener on that option was that if he did so, he would get a 30% reduction of the total penalty. Uh, and and perhaps that is sufficient to induce some employers to enter into the expedited settlement agreement process.
Right. And in exchange for that process, the Avalos would waive the right to contest and also certify that an abatement took place of the citations.
Yeah, and to be very clear, when you say that he would have been waiving his right to contest, that is essentially entering a plea of guilty. And that's the important part here.
Right. So Julio did end up signing the expedited informal settlement agreement and signed it and faxed it over to the local area office. He signed it on Friday and it was sent over and then counter executed by OSHA the following Monday. Um, so once it was countersigned, the director went through, and the process from that point would be to the citations will no longer be able to be contested. But we have a situation where there was an intervention by a safety consultant known as Superior Safety Solutions. And in June 27th, this is after the EIS was signed and transmitted and counter executed by OSHA, Safety Solutions reached out to the area office
In writing.
and indicated that it was representing Avalos in this matter and demanding that a citation contest. I think what's interesting, this is June 27th, so we are still within the 15 working day period, but the sort of weird issue is the fact that the EIS was indeed already signed. So OSHA attempted to clarify with Superior and Avalos ultimately, saying that this agreement was already signed, they cannot contest. But and this has happened on three occasions. But and then a third occasion, a DOL attorney reached out and said that it would not uh, receive the notice of contest.
Not acknowledge the notice of contest because the expedited informal settlement agreement was binding.
Right. So I think it was interesting. They essentially said we won't send this matter over to the commission because the matter's already been settled. So at that point, Superior itself reached out to the commission and filed a second notice of contest directly to the commission, which I thought that was interesting. But in all these instances, Superior never acknowledged or mentioned the EIS agreement that was ultimately signed.
That's right. So Superior said in their first correspondence, we're noticing Avalos Home Improvements notice of contest, but they didn't, in addition, say, and we're revoking the expedited informal settlement agreement, or we are, for the following reasons, not of the belief that this is binding, and they could have given any number of reasons. But they didn't need to. They could have at least said, at a minimum, we're revoking that expedited settlement agreement. And there's other areas of law where a revocation period is either expressly permissible or just as a question of equitable consideration, courts will acknowledge. And but they didn't really take that step. And I don't know why Superior didn't do so, but to state the obvious, this is a safety consultant, not an attorney, and certainly much less so not an attorney that engages in the practice of OSHA law in particular. And that may have had something to do with it.
Yeah.
I think that was probably a choice that Avalos made for reasons other than he wanted, or that Avalos Home Improvement wanted to engage a representative that was the most experienced in the legal implications of OSHA citation contests. And so for whatever those other reasons were, they went with Superior,
Yeah.
who are non-attorneys.
Right.
Which point the judge referenced in his opinion
Yeah.
multiple times, would you
Yes.
say, throughout?
Yeah, the phrase non-attorney representative was frequently mentioned throughout the opinion. And the way that this functionally worked is that OSHA, after this letter was submitted, or after the second contest letter was submitted to the commission, OSHA then filed a motion to dismiss the notice of content for the reasons that we discussed about the EIS already being executed. And in response, Superior filed an opposition brief discussing its arguments. So let's get into those arguments.
Right, because at that juncture, OSHA is stuck in this place of procedural ambiguity,
Mm,
where it has very clearly said through its attorney, there's no opportunity for us to forward this notice of contest on to the commission and open up a case because he's already entered into an expedited informal settlement agreement. So that's kind of it. He's
mm,
pled guilty and the case is settled. There's a finality. The expedited informal settlement agreement is the final disposition of the case.
mm,
And then when Avalos Home Improvement files a notice of contest through its consultant, non-attorney consultant, directly with the commission, OSHA's left in this space of procedural ambiguity where
mm,
it has no choice, I think, or believed it had no choice, but to file a motion with the commission to dismiss that notice of contest and on the argument that there's no opportunity to contest directly with the commission, something that has already experienced a final disposition.
right. It was definitely a unique set of circumstances in
Right.
this case. Um, so Avalos's arguments, this is arguments that they made in their opposition brief. So their primary hinge, I think, in terms of legal arguments was Federal Rule of Civil Procedure 60b-3, which allows a court to give a party relief from a final order because of fraud, misrepresentation, or misconduct by the opposing party. I think this rule is grounded in this principle of equity, which is broadly ensuring fairness. Um, so the primary arguments that Avalos, I think you can boil it down, they basically said that because Julio's ability to understand English was limited, that prevented him from understanding the EISA when he signed it. And OSHA knew about this and essentially took advantage of it. But I think the problem that we already hinted at, and definitely the ALJ discusses, and certainly OSHA points out, is that they failed to provide supporting evidence to substantiate these allegations. The arguments were essentially toothless because they were just made as that. They were saying, well, he didn't understand it. He couldn't have understood. He struggled to understand English. He couldn't understand the ESA. Therefore, it should be the agreement should be invalidated. And then also later during a party conference within the parties, the superior representative orally claimed that Julio he lacked the authority to sign EISA because he was not a owner of the company. Um, and in the background, while
He
this,
claimed his wife was the 100% owner,
yes, exactly.
which is weird because when he signed the expedited informal settlement agreement, he signed it Julio Avalos, comma, owner.
Right, right.
So he says he self-describes himself as the owner, and then with his non-attorney consultants defending him, they make the argument that he's not really the owner.
Yeah.
Uh, they really should have looked at the file more carefully, investigated the facts more carefully before positing that argument in the very first place.
Yeah. And I think it's telling to that end because when this conference happened afterwards, the ALJ said, you know, I need additional supplementation of the record. Please provide support for these allegations being made on both sides, giving both OSHA and Superior and Avalos an opportunity to do this. But Avalos failed to take advantage of that opportunity. There was no supplementation that ever took place, which I think ultimately was a cause of frustration on the part of the ALJ.
Right. Not only did they not submit anything, but they specifically declined because I believe, if I recollect afterwards, the commission called them and said, you haven't submitted anything.
Mm-hmm.
And they, through their consultant, said that they have elected not to submit any briefing with any supplied evidence in support of these arguments.
Yeah, I think a strange choice.
I could say, before you make an argument, you've got to find out whether there are facts in evidentiary support of the argument. And I don't know any defense counsel, and specifically any OSHA law defense counsel, who would not supply evidence in support of their arguments.
Mm-hmm.
It's an unimaginable omission in that community, I think.
Right.
So the next question was whether or not the expedited informal settlement agreement is indeed a final order.
Right. And OSHA argues that it was indeed a final order. And it cites case law and other precedent discussing how, a final order is essentially created in three ways, by either failing to contest a citation within 15 working days that automatically makes it a final order, non-reviewable by the commission, um, or contesting and ultimately obtaining an adjudication from the commission, or number three here, as in this case, entering into an informal settlement with OSHA within the 15-day working period. So that was the argument on why the order was final. And then OSHA argued that Avalos failed to meet its burden under the Rule 60 argument. It essentially said that the burden of proof in that situation, when you're claiming that some kind of an injustice took place and the court needs to provide relief, the burden is on the party making that motion to provide evidence to substantiate it. And in this case, Avalos failed to provide any evidence, like we discussed, to substantiate
Right,
it.
and OSHA argues that not only did they not supply any evidence, but here's evidence in favor of our assertion that Julio Avalos indeed did have a proficiency with English, and here's evidence that Julio Avalos was indeed an owner of Avalos Home Improvement. And so they have clear evidence that the administrative law judge credits on both those arguments, and by contrast, Avalos Home Improvement's representative supplied none.
Right.
What is the judge to do in that case?
Exactly.
It's pretty easy.
It's entirely one-sided. And I think this is also an argument that was discussed, is that they did bring up the fact that there was a notice that was provided in Spanish on the cover letter packet. So even if there was some question as to Julio's ability to understand English, he was on notice by that notice to, obtain a translator or to contact the area office for further clarification.
Yeah, it's interesting. I do wish that masthead language in Spanish that was on the face of the citation would have also been on the face of the expedited informal settlement agreement, page 2. That would have been better,
I think so.
but surely the message was there and he could have read it and taken it to heart, the words that this document is very important. And if you don't understand it, get a translator or call the area office. Should have been a universally applicable precept that I think Avalos should have taken to heart.
So in terms of the decision, we start off with the question of whether it was a final order, and the ALJ agrees that indeed the executed EISA did constitute a final order. It also discussed that Avalos, like we were just discussing, that Avalos failed to meet its burden under the Rule 60 argument to obtain relief. It, like we discussed, failed to provide any evidence to substantiate the claims that it made. The evidentiary record was one-sided, and like you mentioned, OSHA did provide both documents showing that he provided recent documents that Julio signed that were English as evidence that he could understand it, and also provided documents showing that he was the owner of the LLC in Wisconsin. The ALJ also discussed how the EISA should be enforced under the general principles of contract law, and the principle in this case being that it's presumed that when you sign a document, you understand its terms and agree to be bounded by them. This is only does not apply if there, like we discussed, if there's fraud, misrepresentation, or some kind of misconduct on the part of the other party, which was shown here.
Those are the three primary methods by which a party can attack the validity of an alleged contract: fraud, misrepresentation, or some kind of misconduct. Avalos Home Improvement didn't argue any of those. There could have been the possibility of evidence that evidence existed in support of one of those arguments, but he actually didn't make any allegation that there was any fraud, that there was any misrepresentation, or that there was any misconduct. I suppose this idea that his English was imperfect and that the compliance officer knew it but asked him to sign the document anyways, maybe should be very broadly and leniently interpreted as an allegation of misconduct. But I don't see that being clearly articulated as a doctrine of law by Avalos Home Improvement's consultant representative superior. I think that they just said flat out, well, his English isn't so good, and so maybe he should be given a break here. It shouldn't be enforced against him. But I think it would have helped if he had articulated maybe something similar to that argument within the framework of known and acknowledged legal defenses. and maybe as well, as we already talked about, supplied some evidence to support that.
That would have helped. And the ALJ also discussed the argument that was orally raised by Superior during the conference with the parties on the issue of authority. And I think it was interesting. The ALJ said that, even if there was a credible argument, it's an argument that was made orally and it was never mentioned in the papers. And Avalos never took advantage of the opportunity to supplement its papers after the LJ gave the opportunity. So the argument was considered waived in that case. So because of all these things, the notice of contest was dismissed. And I think, like we discussed before, there was a footnote at the end of the decision that the ALJ highlighted the issues with Superior's presentation of the allegations in this case, essentially reminding both parties that whether you're attorney or non-attorney, anytime you're submitting papers before the commission, you have to have a well-grounded belief after reasonable inquiry that the allegations are grounded in some kind of fact. And I think there was an overall concern that the superior represented in this case might have not met that standard by the way that the arguments were presented.
Yeah, that's right, Ben. It exists in every tribunal, this idea that in federal rules of civil procedure, you might call Rule 11, where the person making a statement to a court has an affirmative duty to first validate whether that statement is true, grounded in fact, and has evidentiary support. And without doing that due diligence, that basic inquiry as to the truthfulness of your own statements, you may run in violation of that rule. And there's a analogous rule in the Occupational Safety and Health Review Commission's procedures as well. But I think this is a really important point, and clearly the judge thought so too, or else he wouldn't have taken the time to put that on the face of the opinion. It's usually something that I've seen after the opinion.
No, it's an unusual thing to include.
Right. So, in light of the judge's decision, and I think that the real moral of the story is it goes to the expedited informal settlement agreement. What do we think employers should do?
So one of the first takeaways I think that we can look at is just clarifying internally and in corporate documents who the company's point of contact with OSHA is and who is authorized to bind the company to any commitments with the agency.
In addition, I think it's important for employers to work on training the managers, the supervisors on staff as to how to properly handle on-site inspections with compliance officers, as well as the procedure after the on-site inspection is concluded, and then the steps that come after that, including requests for information, informal conferences, and of course the expedited informal settlement agreement. If the supervisors are not sufficiently trained on those, I think substantial opportunities will be lost. But second to that, I think that those supervisors should be trained to associate somebody within the company who is more versed in these procedures so that the company can get adequate representation from their management team.
Yeah, exactly. And I think related to that point is also by adding the issue of dual language issues. If address language issues proactively, if you anticipate in some industries where there's another language or lack of English proficiency that may be an issue, discuss that with employees that may have a limited understanding of English to ensure that they're trained properly on what to do when a citation takes place. So there's not an opportunity for confusion to cause issues later on.
In addition, I think it's important for employers to, when going through this process, to verify that they are engaging representatives on behalf of their company that are experienced and well-versed in OSHA law and the procedural implications of an inspection and the contest process and settlement agreements. I don't think that you can pick your counsel too carefully. Preferably somebody who is experienced in OSHA law in particular and in citation contests in particular.
And then finally, maintain robust record keeping. I think this is something that we very frequently discussed, but it's incredibly important to preserve the record to when issues come up later down with potential citation contests or settlement discussions. You want to have documentation on your side to be able to negotiate with OSHA, and then later on, if it gets to the citation contest stage, to be able to present it before the commission.
Right. And I think it's also important that when a citation is presented or an informal conference, the possibility of settlement is presented, or alternatively, the expedited informal settlement agreement is presented. I think it's really important to carefully consider whether or not the expedited informal settlement agreement makes sense in that particular case. Certainly, that's 30% discount to the penalties was a factor to consider, but other factors go to, as you pointed out, Ben, I mean, there's an abatement uh, period as well as an abatement certification. And OSHA has dictated what the abatement should look like through its proposed abatement. And then when you sign the expedited informal settlement agreement, that proposed abatement becomes the abatement that's imposed on you de jure. And so those are the other factors that I think you need to consider. And in addition, whether or not there's bona fide defenses. It's not entirely inconceivable that the compliance officer has misunderstood something or gotten some fact wrong.
Mhm.
Maybe the citation is improvidently issued. And I think that if there are bona fide defenses to be raised, then the expedited informal settlement agreement might not make perfect sense
Mhm.
in those particular cases. Those are the takeaway items for this month's OSHA 3030. Well, thank you all for participating. Remember what we've always asked when you get an invitation for next month's OSHA 3030, we ask that you forward it on to at least three other people, not only in your organization, but at other organizations, safety and health professionals, but also folks in your office of in-house counsel who are responsible for OSHA law compliance. Our next program will be at 1 p.m. Eastern on December 17th, 2025. We have sister programs you should know about, the Reach 3030 and the Tosca 3030. Their next programs are both on December 10th, 2025 at 10 a.m. and 1 p.m. respectively. Hope you forward those programs as well to your folks in-house, as well as the other professionals in your organization responsible for compliance with Tosca and Reach. Thank you all for participating in this month's OSHA 3030. I'd also like to thank the staff here at Keller and Heckman for helping produce this show. And Ben Idzik and myself are both thankful to all of you for spreading the good word about the OSHA 3030. And we look forward to seeing you again next month. And until then, stay safe.